as we noted before, there are, as I noted before actually, there are 13 states that regulate the sale of franchising, sale of franchises. New York, for example, has a franchise Sales Act. California has a franchise investment law. These laws require require the provision of an FDD to a franchisee prior to the sale in a certain time frame, and require certain information to be followed. The form of the document is actually governed by an organization called NASA, NASAA, NASAA, and the Federal Trade Commission has its own set of regulations, but they sort of match, not entirely. And the information that's provided is what has been deemed by the legislatures in their protective capacity, because it is intended to protect a franchisee in the context of a franchise sale. Information that's important for a franchisee to make an investment decision. The genesis of this is actually interestingly stated in the New York franchise law. I've never seen I'm sure there are, but in my practice, the only time I've ever seen as much legislative history about a statute actually written into a statute is in New York. And the general business law governs the sale of franchising in New York, and there's a whole history of franchising and the fraud that was committed against franchisees, or prospective franchisees and franchisees during the years before the franchise legislation was passed in 1979, that persuaded the state government and other governments in other states to enact regulations and laws that protect franchisees. Federal Trade Commission also enacted a provision. California was the first state that created a franchise protective statute, and the number of states, as I said, 13, have similar laws that protect and require franchisors to provide franchisees with this type of information. The Federal Trade Commission, as I said, regulates it, and it's nationwide, but it's the state laws specifically that govern the private litigation between franchisors and franchisees, because the Federal Trade Commission rule does not allow for litigation or private rights of action against franchisors. It's a regulation that franchisors have to abide by. The Federal Trade Commission enforces some of those regulations, not frequently, enforces the regulations, but most of the litigation, all the private right of action litigation, is brought under the state laws. And that's why it's important to look at the various state laws that might apply. For example, again, you might have a franchisee in New York and a franchisor in New Jersey. New Jersey does not regulate the sale of franchise businesses. But and the law, and it may provide in the franchise documents that the law of New Jersey applies. And if your franchise client is located in New York law will apply to the sale of that franchise, and the franchisee located in New York will be protected by that law. We've indicated. There's a question up on the board, and I'll answer that in a moment. We've indicated that the Federal Trade Commission regulates the sale of franchises, and some state laws actually allow you to bootstrap, use the FTC regs to support a private right of action under unfair trade practice provisions of the law or consumer laws. The question we're getting is there a basic rule regarding how the radius restrictions are applied regarding whether they are based upon street distances or as the crow flies, or something that has to be specified in the franchise agreement to avoid a dispute? The answer to that question is that there's been a lot of litigation over how much of a radius does apply. You have to go to the franchise agreement specifically. Some franchise agreements give geographical boundaries. So Main Street to North Avenue, to the north and the south, and other streets, to the east and the west, and you get an actual specific geographical area. Some are, as the crow flies, 2-mile radiuses, and I've litigated the issue a couple of times involving this, and the distance between the franchisee that was complaining and the location that he was complaining about was 2.5 miles by road, but less than 2 miles as the crow flies, and the crow won. And the litigation was successfully completed on behalf of the franchisee, because the agreement specified that it was just a radius distance, not a geographical boundary requirement. I will say, as we have said before, and I'm sure Jim's seen this as well, that many franchise agreements have done away with the idea of providing any territorial protection to franchisees at all because of all the litigation over these issues.
Right, and so the answer to the question is it's entirely a creature of contract. It depends on what the contract says, and the parties can decide how they're going to measure a territory. But there are an infinite variety of variations on how people can do that. Can be as the crow flies, can be as the street travels. It can also be, for example, I'm aware of many franchises have, say, I can put a franchisee anywhere within a territory, including right next to you, but within this particular area, I can only put so many franchises based upon population count, for example. So it all depends on what the franchise agreement says.
Right. And a lot of this, a lot of the litigation that took place in the years where we started practicing in this area have dictated how franchise agreements have resolved those issues or have addressed those issues. And again, franchisors are preparing the agreements, and they're, at least on most issues, not very negotiable, particularly in mature brands. And so the result of that is that the franchise agreements provide less and less protection to franchisees relating to territory, and protect the franchisor more and more. You know, there have been angles that have been tried relating to litigation, good faith and fair dealing, for example, where, notwithstanding the fact that the territory was, say, a 2-mile radius, the franchise pursued a litigation where his store was being competed against by something 2.5 miles away, and said, I should have been protected in this trade area as well, and it was where his customers came from. Successfully, not successfully on behalf of the franchise because the agreement specified what the territory was, and the good faith and fair dealing argument didn't work. On the other, I'll give another example of that. On a case that I dealt with a number of years ago, the franchise agreement provided for a 3-mile radius, but my client was sharing information about its sales with the franchisor and where its customers came from, zip code information. The franchisor took that information and used it to set up a store down the road, 4 miles, 5 miles away. But it was I was not protected by the territorial provision of my client's franchise agreement, but I was protected by what I claimed was a breach of fiduciary duty, using the information that my client provided to the franchisor that the franchisor used to compete against my client. And we successfully resolved that case. So there are a number of different arguments that can be made. It's getting harder and harder to protect franchisees in this area, but you have to look at all the angles. Franchisors have also dictated in their agreements that franchisees are provided with a territory, so if they are provided with a territory at all, but that the franchisor maintains the right to engage in alternative distribution channels. And that might be the internet, it might be mail order, it might be setting up in what's called a non-traditional location, like a stadium or a train station. And franchisees...
Supermarkets?
Or supermarket, right. So, you know, getting back to, say, the ice cream franchise, one very well-known franchisor of ice cream store in the ice cream business, sold its product both to franchisees and to supermarkets located in the same shopping center. And there was a fight about whether or not the franchisor could do that. And the franchise agreement protected the franchisor because the product couldn't be sold. And the next version of that franchise agreement said it can be sold in supermarkets even if they're located right next door to you.